many of the cases concern occupational freedom. You know that there have been constitutional challenges filed against the Korean bar exam that you take. Some students, some schools, not having the law school program, thought that it was unconstitutional to deny non-law students a chance to sit for the bar exam. And even before that, there was a challenge by those who failed the second stage bar exam, not the current bar exam, but the previous one. What's that noise? Okay, right. Anyway, okay. Maybe it's air conditioning. Yes? Okay. All right. So, even previously, those who failed the previous bar exam, they also filed a constitutional challenge because they passed the first stage, which is graded on the absolute standard, but they failed the second stage, which is graded on the relative standard, which means if they are not within the first 1,000 or the highest 1,000 people in the second stage exam, no matter how well they did in the exam, no matter how qualified they are, they could not pass the exam. And there are many other occupational freedom cases in Korean constitutional law. So that's why we start with that. And we're going to come back to the problem of the Korean bar exam later. Okay. So, page resource book, page 290, U.S. versus Caroline products. So, what was the issue here? But what is filled milk? Filled with what? Filled with what? Filled with vegetable oil. So there's whole milk, and they take out the fat, and then they add vegetable oil instead. And they banned it. Why do they take away the fat from the milk? To make butter and cheese, right? So it's like how they make 안동소주, right? They ferment the rice. They take out 안동소주 first, and then they take out 동동주, and the remainder becomes 막걸리, right? So, there's the same gradation of dairy products. The first fat is made into cheese, the remainder made into butter. And what remains, really nothing, but instead of throwing it away, they added different type of fat and sell it as milk, right? The government banned the product. Now, I mean, what's the problem, right? The people selling the filled milk and also the dairy producers, they don't want to throw away something that people want to buy. And there is no finding that filled milk is bad for you, because there's nothing harmful in it, except if people stop drinking milk because they are drinking filled milk, yes, it will result in undernourishment. They'll get less nutrition than they would have received from real milk. That's the idea. So let's look at the facts. Page 298, the small letter paragraph. Butter fat is rich in vitamins that are wanting in vegetable oils. The use of filled milk as a dietary substitute for pure milk results in undernourishment. Now, but if people are willing to drink it instead of a whole milk, now is filled milk cheaper than whole milk, real milk? Of course, right? So if you go to market, you can buy crab meat, 게살. When do you buy real crab meat? Not many times. The crab meat that your parents feed you at home, a lot of times is not crab meat. It's made of fish, right? What's wrong with letting people buy what they like at a cheaper price at a similar but little bit lesser quality than the real one? These chairs, they look like something. They look like leather, but that's not real leather. I'm sure this will cause more skin irritation if you come in contact with it on your bare skin than when you come in contact with the real leather. But school cannot afford real leather chairs. So what's wrong with having people eat filled milk? Who filed the lawsuit here? Well, it's not clear, but probably the people who, the dairy producers, right, who didn't want to throw away the remainder after making butter, and the people who are making profits selling them. So their idea is the entire industry of filled milk is wiped out by this law for no apparent reason. There is not much public interest in prohibiting people from buying cheaper milk. What does the court say about that? Now, you've already learned from the previous cases that standard of review is important. Okay, what standard of review is used? Is it heightened review or low review?
Rational basis review.
Okay, how do you know that? What is the text that you read that from?
The second paragraph.
Okay.
Page 36.
All right. So, page 291. Well, the existence of a rational basis for legislation depends upon facts beyond the sphere of judicial notice. Such facts may properly be made by the subject of judicial inquiry, and the constitutionality of statute predicated upon the existence of particular state of facts may be challenged by showing to the court that those facts have ceased to exist. Similarly, we recognize that the constitutionality of a statute, valid on its face, may be assailed by proof of facts tending to show that the statute as applied to a particular article is without support in reason because the article is so different from others of the class as to be without the reason for the prohibition. Now, go down a little bit and right in the middle. But by their very nature, such inquiries, where the legislative judgment is drawn in question, must be restricted to the issue whether any state of facts either known or which could be reasonably assumed affords support for it. Three lines down. The question is at least debatable whether commerce in filled milk should be left unregulated, or in some measure restricted, or wholly prohibited. As that decision was for Congress, the act is constitutional. So the idea is that in a case like this, rational basis review will be applied, and unless there is no support, right? Unless there is no support for the legislative finding, the court will not second guess. second guess는 이제 재심하지 않는다는 겁니다. Second guess, 재심. Will not second guess legislative finding. So if you go back to the second letter, the small letter paragraph on page 290, the court says, like right in the middle, despite compliance with the branding and labeling requirements of the Pure Food and Drugs Act, there is a widespread use of filled milk as a substitute for pure milk. Okay. Now, by the way, this is not what the court said. This is what the Congressional Committee, right, at the top. This is what the legislature found, right? Legislatures found that a lot of people are not drinking whole milk and instead drinking filled milk. And filled milk doesn't have the vitamins present in whole milk. Well, what if people choose to drink it? Well, the legislature says this is aided by their identical taste and appearance and by the similarity of the containers in which they are sold, by the practice of dealers in offering the inferior product to customers as being as good as or better than pure condensed milk sold at a higher price, by customers' ignorance of the respective food values of the two products in many sections of the country, by their inability to read the labels. So for all these reasons, a lot of people think that either they are drinking whole milk, okay, either they are falsely believing that they are drinking whole milk, or they are falsely believing that whole milk is they are falsely believing that filled milk is as good as whole milk. That is the finding. Okay, then the court says, okay, then that is a support for that is a rational basis. That is sufficient to make the statute constitutional. I'm sure the plaintiffs in this case presented other findings, saying, hey, most people drinking filled milk know that they are drinking filled milk. And also most people drinking filled milk know that there is usually better and more nutritional substitute, which is whole milk. But the court is saying, no, 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 no. We don't need to look at it because we are conducting rational basis review. The question you should ask is this. Well, let me tell you this. Why is people's right on one hand, I mean, what rights are at stake, right? So I told you constitutional reasoning is basically balancing between public and private. And what interest is infringed by this action of banning filled milk? Look at page 291 at the bottom. To expropriate the property of a lawful and beneficial industry, to deprive working and poor people of a healthful, nutritious, low-cost food, and to impair the health of the nation's children by encouraging the use as baby food of a sweetened condensed milk product that was 42% sugar. So I bet there were a group of other dairy products, dairy producers, who would stand to gain from this legislation, because they want to sell whole milk, and if people are drinking filled milk, they'll be selling less of what they are selling. That's why the commentator is saying this was a special interest legislation. 우리나라 따지면 이제 이익집단의 로비에 의한 입법이었다. Now, many laws regulating freedoms, many laws regulating occupational freedom are lobbied for or against by special interest groups. Korean profession of law is one of them. Let me get back to that. But for now, let's look at this. So, what interest is being infringed? People's right to eat field milk and people's right to make a living selling field milk. I mean, these are all very important rights. Why is the court applying rational basis review? All right. So I guess right to eat field milk and right to make money selling field milk is not a fundamental right. I told you that when a right is fundamental right, the court will apply strict scrutiny. And freedom of speech was considered fundamental right. That's why they apply high-level scrutiny, which we often call clear and present danger test. But here, the court is saying, legislation may be wrong, but it's their decision. Does this remind you, their attitude, the court's attitude, does the court attitude remind you of some case we discussed early this semester? Which case? Think methadone, right? Beezer case. There, the plaintiffs show that at least 1/3 the methadone users are as good as non-methadone users. But the Supreme Court said, okay, you may be right, but still the law is constitutional. Because it does not involve, according to the court, any suspicion of a bias against a minority group, a minority group defined by immutable traits. When does strict scrutiny come in? History of discrimination plus immutable traits. This gives suspicion of bias against minority. So far, the only such groups considered to fit this description has been race and gender. So, if you look at this law, it is restriction on right to eat field milk, but it is also discrimination against people wanting to eat field milk. And if you look at it that way, then you have already solved the problem. You already know what to do with this case. A lot of times, restricting somebody's freedom is a discrimination against that person for exercising that freedom. So since you have learned something about equal protection already, I mean, you can engage it from freedom angle, you can engage from equality angle, but you arrive at the same result here. Any question, comment on this case? Right, if not, let's go to page 292. Williams versus Lee Optical. Okay, what happened in this case? An ophthalmologist is an eye doctor. Optometrist, 검안의죠, 검안의. An optician, 안경사. In Lee Optical, the court considered the constitutionality of an Oklahoma statute that made it unlawful for an optician to fit or duplicate lenses without a prescription from an ophthalmologist or optometrist. Okay, how about this? So the law made it impossible. Law prohibited opticians from adding lens to the frames. How is this law justified? I mean, adding lens to the frames is just purely mechanical act. Why is the law prohibiting, or why is the law requiring the fitting of lenses onto the frames to be prescribed, to be approved by an eye doctor or an optometrist? What do you think is the public interest served by such law? So the idea is, let's say I have these glasses, and let's say the lens broke. You'll go to optician, 안경사한테 가겠죠. And they'll usually make the same lens and just fit it back to you. But in America, back in, when was this? 50s, you couldn't do that. You had to go back to the eye doctor and get another prescription. And then, I mean, even now, if you go to optician and ask the optician to make glasses for you, they'll not do that unless optometrist or eye doctor measures your eye. Okay? They'll sell you sunglasses. They'll sell you 돋보기. They'll not give you the ordinary glasses without optometrist prescription or eye doctor's prescription. But how about just fitting of the lenses after you get the subscription? I mean, after you get the prescription. So back in 1950s in the United States, in state of Oklahoma, they said even that should be done under the supervision of optometrists and ophthalmologists. What do you think about this law? What happened in the lower court? The lower court said, page 292, the first big paragraph, the district court, 연방법원, 하급심법원은 district court라고 한다고 말씀드렸죠. District court held that through ordinary skills, the optician could take a broken lens or fragment thereof, measure its power and reduce it to prescriptive terms. 무슨 얘기냐면 렌즈가 남아 있으면 깨진 렌즈 가지고 똑같은 렌즈 만들어서 끼워줄 수 있다. That the requirement of a prescription from an ophthalmologist or optometrist was thus not rationally related to the health and welfare of the people. So what's the public interest being served by the requirement of prescription? Anyone? Well, all medicine are also all poison, right? Any medicine, if you take it wrongly, it can kill you. Same thing with glasses. Glasses are, yes, supposed to help your vision, but if you wear wrongly, or if you don't wear the right lenses, they can actually harm your vision, harm your sight. So that's why the law is in there to protect the public from reduction of sight. And this record said, hey, optician can do that. What does the Supreme Court say about it? The court says, all the way at the top of the second big paragraph, the Oklahoma law may exact a needless wasteful requirement in many cases, but it is for the legislature, not the courts, to balance the advantages or disadvantages of the new requirement. It appears that in many cases, optician can easily supply the new frames or new lenses without reference to the old written prescription. The legislature might have concluded that frequency of occasions when a prescription is necessary was sufficient to justify this regulation of the fitting of eyeglasses. Frequency. 안경 바꾸는 게 뭐 안경 렌즈 바꾸는 게 안경 깨트려 먹는 게 뭐 한 달에 한 번씩 일어난 일이 아니잖아요. 1년? 2년? 뭐 3년에 한 번씩 일어날 수도 있는 거고. So it's okay because your eyesight might have changed over that time period. Right? 또는 or the legislature may have concluded that eye examinations were so critical not only for the correction of vision, but also for detection of latent ailments or diseases. That every change in frames and every duplication of a lens should be accompanied by a prescription from a medical expert. So, the funny thing is, the court is not saying that that is true. The court is not saying that eye examinations are so essential. The court is not saying that, you know, people change frame and lenses only after a certain period. The court is just saying, oh, the legislation may have decided that, right? Because there's a rational basis. Even if it was not the real basis, as long as there is a possibility of justifying the law, then it will become constitutional. So we know that this is, again, rational basis review. Again, apparently, you know, right to where, okay, right to get right to get duplicate lenses or frames, or right to sell, okay, right to sell duplicate lenses or frames. Apparently it's not important enough to trigger strict scrutiny. Pretty disappointing, huh? 여기서 이제 duplicate lens라고 하는 이유는 안경 아래 금이 가면은 그것하고 똑같은 복제 렌즈를 받아서 이제 끼워야 되는 거니까, 또는 프레임에 금이 가도 똑같은 프레임을 만들어서 이제 다시 끼는 거니까, 그러니까 똑같은 걸 그냥 하면 되는 건데 그걸 못하게 하잖아요, 그죠? 꼭 반드시 가서 새로 이 돈을 내고 진료를 받아야, 검안의나 아이닥터한테 돈을 내고 진료를 받아야만 이 부서진 안경을 복구할 수 있도록 하고 있는 거죠. So, do you think this is a special interest legislation? What do you think? Do you think that this is special legislation just as the Field Milk Act is special legislation? What do you think? Who do you think lobbied for this law?
Eye doctors.
Doctors. Doctors were out on the street last week in Gwanghwamun to lobby against what? So Moon Jae-in wants to cover more services under national healthcare system. 지금 이제 급여 항목 있고 비급여 항목 있죠. 급여 항목이라는 거는 의료보험으로 처리가 가능한 서비스를 급여 항목이라고 하고, 비급여 항목은 의료보험으로 서비스가 안 되는. 근데 급여 항목을 늘리는 거, 의료보험으로 커버가 되는 서비스를 늘리는 거는 국민들한테 좋은 거예요, 안 좋은 거예요? 당연히 좋은 거죠. 근데 그거 반대하려고 의사들 광화문에 나와 있었죠. 근데 국민들한테 그렇게 뻔히 좋은 걸 왜 어떻게 그렇게 나와서 반대할 수 있었을까요? Special interest. The idea was that they are making a lot of money of non-covered services. Now, if they are covered, people getting the services will go through healthcare to receive the services, and the reimbursement, right? Reimbursement the doctors get for the covered services is much less than the commercial rate they would have charged to the customers. So this is another law that was affirmed by the Supreme Court, although it was a special interest legislation. Right below, okay, the second letter paragraph, 뒤에서부터 2, 4, 6, 8, 9th line. To be sure, the present law does not require a new examination of the eyes every time the frames are changed or the lenses duplicated. What does it mean? Present law does not require new examination of the eyes every time the frames are. 여기서는 이제 이것만 봐가지고 이제 알 수가 없는데, 여기서 이제 빼놓은 게 뭐냐면, there are exceptions to the law. Sunglasses and 돋보기. For them, because sunglasses and magnifiers, magnifying glasses, because they don't require eye exams from the beginning, when they get duplicate ones, they don't require eye exams either. So that's another argument, right? Hey, if really, so the plaintiffs are saying, hey, if the really goal is to protect people's eye health, then why do you make an exception for sunglasses and magnifying glasses? What do you call this problem between over inclusion and under inclusion? What is this? This is under inclusion, right? I mean, if the goal is protecting people's eye health, why not? I mean, why make exceptions to sunglasses and magnifying glasses? That will hurt people's vision as well. I mean, the problem before that was over-inclusion, right? Because, hey, protection of eye health is good, but making duplicate lens, right? Making duplicate frames, that's not a medical act. Anybody can do it. Anybody without medical science can do it, right? Any engineer can do it. And if the patient says, okay, I want to continue wearing the same glasses, it's their right. Unless the law requires people to change glasses as vision improves or vision regresses, right? 자기 시력에 맞춰서 안경을 써야 된다는 게 그런 법이 있는 게 아니잖아요. 자기 시력보다 낮은 거 또는 더 부족한 거 쓰는 것도 그 사람들 자유인데 안경이 부서졌어. 아, 병원 가서 이것도 새로 조사를 하느니 맞는 새로 시력을 검사를 하느니 아, 그냥 지금 있는 거 편하게 쓰겠다. If it's their right, then they should be able to get duplicate lens and glass without exam. But the law is over inclusive there, right? because it's requiring, it's covering, the coverage of law is too broad. It includes even duplicate. It includes even duplication. That's over inclusion problem. Now we are talking about under inclusion problem. If the law, if the protection of health is that important, why make exception to sunglasses and magnifying glasses? So, but you know what the court will say? The court says, the law need not be, in every respect, logically consistent with its aims to be constitutional. It is enough that there is evil at hand for correction, and that it might be thought that particular legislative measure was a rational way to correct it. The days gone when this court uses due process clause to strike down state laws. Let me explain about due process, why the court is saying due process clause a little bit later. It's a boring lesson, but you'll have to learn about it. But for now, let's just assume that there is a provision in the American Constitution concerning non-speech freedom. We talked about freedom of speech a lot, and we know that First Amendment is the provision protecting freedom of speech, and there's got to be some provision protecting rights in general, like our Constitution. Which provision has general protection for all rights in our Constitution? Anyone remember? All the rights, all the restrictions on all rights, or any right, has to be approved through this provision. What is it?
Article 37.
Yes, Article 37, paragraph 2. Right? And there must be some provision like that in the US Constitution, right? Right now, it's due process clause. It's a surprise, right? due process는 이제 적법 절차 조항으로 알고 있었는데 it just shows up. I'll explain a little bit later. Okay, but let's move on to Ferguson versus Scarpa. Well, you can just read it yourself. It's the same story again and again. Okay, so I guess now I can talk about, first I can explain why due process is involved. So, Fifth Amendment. Fifth Amendment Constitution and 14th Amendment Constitution say the same thing. No person shall be deprived of life, liberty, or property without due process of law. And you've learned due process clause already, right? When we talk about Gold versus Kelly, I told you that the Warren Doctrine is closely related to the due process clause. I mean, it does not need search and seizure or Warren Doctrine don't need another provision, another textual support for it, because they already have Fourth Amendment and Fifth Amendment. That's fine. But the spirit of the Warren Doctrine comes from the due process philosophy. Basically that if the state wants to take something away from you, it has to go through a due process. What's the due process? Notice, right? Right to object, right to notice, right to object, and decision by an independent officer, right? That is the due process. Now, Fifth Amendment, I told you that 1 through 10 amendment, it's not really amendment, but it was part of the main body. And 1 through 10th amendment was applicable to federal government. 1 through 10th amendment was attached toward the end because the framers decided, oh, if you make this central government, their power may become too big. Let's restrict their power. By what? By adding these constitutional provisions. So 1 through 10th amendment applied to federal government. And then there was a war between the states. Well, the north side won. And what was the war about? Slavery, whether to continue slavery. The southern states wanted to continue because they needed all the cheap labor for their cotton plants, cotton plantation. The north side, where the factories were, they needed cheap labor. They needed to free up the labor from the cotton plantation so that they could hire them, right? So there was a war, the North won, and in order to make sure the southern states do not continue holding on to slavery, 13th through 16th Amendment was passed. So we call this post-war amendment, post-war amendment. And 14th Amendment repeated what 5th Amendment said. 5th Amendment was applicable to the federal government. So this means federal government cannot deprive person life, liberty, or property without due process of law. 14th Amendment applied to the states. I mean, 1 through 10th Amendment was based on the worry, based on the concern that federal government may become an evil, right? The federal government may exercise tyranny, dictatorship over people. But after the war, during the war, or before the war, right before the war, they realized that, hey, individual states can become a tyranny. dictatorship. We need a restriction on the states as well. That's why they added the same clause on the 14th Amendment. Now, okay, so we all know the history and the ordinary meaning of due process clause. But later, people realized that there is much more riding on the due process clause. Basically, 1 through 10th Amendment, they have freedom of speech, right, unreasonable search and seizure, right to counsel. There are all these good rights in the 1 through 10th, but they are not applicable to the state governments. But during the war, they realized that states can be bad, so they wanted to apply 1 through 10. They wanted to apply the contents of 1 through 10 to states as well. And they figured out a way of doing so. How? Well, through 14th Amendment due process clause. So we call this incorporation. 준용. 준용 원리. 어떻게 준용하냐면 no person shall be deprived of life, liberty, property, liberty. 에 1 through 10이 다 들어있는 것으로 가정을 하고, 여기서 due process of law라고 했는데 어떤 자유를 제약할 때, when you are restricting a certain right, you do that for, you have to do that on the basis of certain fact. For instance, the Field Milk Act. What's the supporting fact of the law? Well, that many people are falsely believing that they are drinking filled milk, and many people are falsely believing that filled milk is as good as whole milk. And the legal scholars realize that when you pass a law like that, right? When you pass a law on the basis of a statement that has not been proven, then it's like violating due process, because the state is making assumption without testing it, right? The state is assuming, without going through a hearing, without giving people a chance to rebut, without having an independent officer to make a decision, the state is making this assumption and passing the law on that basis, on that assumed, not proven, but assumed basis, then that is like a violation of due process. But you know that that's not the usual way of understanding procedure that's not the usual way of understanding due process, right? Due process means, okay, even if the government can do something substantively, the government has to go through certain process to respect their citizens. That's the idea of due process. Here, the legal scholars are saying, oh, yes, banning filled milk, it is substantive, it's not procedural. But it is like, we can make it like a procedural defect. Basically that, the Congress did not give people notice of the finding that it's making. What's that finding? That filled milk is bad for people. And has not given people a chance to respond, and has not put the question up for decision by an independent officer. So it's like a procedural due process. But really, if you look at the content, then you'll know that, right? This is really a substantive stuff going on. So we call this so it needs incorporation to apply to states. And then here, substantive restrictions are actually like procedural defect. And we call this process, using procedural due process clause to challenge substantive restriction, we call that substantive due process, SPD, or not SDP. And most of the rights, most of the rights other than speech are covered under substantive due process. If there's a law banning smoking, it will be covered under substantive due process. If there's a law banning chewing gum on public street, it will be covered under substantive due process. You know that there's a country where chewing gum on public street is illegal. Where is that? Singapore, yes. If there's a law against walking on hands, it will be covered under substantive due process. Because the term liberty is so expansive, right? And if there's a law against eating filled milk, what will that be covered under? Substantive due process. How about law against making duplicate lenses? Covered under substantive due process. Okay, we'll take a break. for 15 minutes. Now let's look at Smith versus Texas. So the question is this: can there be a law restricting non-speech rights? Okay, can there be a law restricting non-speech rights that can be struck down unconstitutional? Is there a way to strike down a law that can be struck down? Can a non-speech restricting law be struck down under rational basis review? Now, you have not seen a case where a law has been struck down as unconstitutional under rational basis review. But let's look at Smith versus Texas. It is an old case from 1914. Smith, the first paragraph, the first big paragraph. The plaintiff in error, a man 47 years of age, had spent 21 years in the railroad business. He had never been a brakeman or a conductor, but for 6 years he served as a fireman. For 3 years, ran as an extra engineer on a freight train. For 8 years, was engineer on a mixed train, hauling freight and passengers. And for 4 years, they've been engineer on a passenger train of Texas Gulf Railway. But the law, and July 22nd, 1910, he acted as a conductor. 그래서 차장이 제일 높은 거죠, 지금. 쭉 말한 직종 중에서 this is the highest position, conductor. So for the first time, he acted as a conductor of a freight train, right? And he was found guilty of the following offense. Section 2nd. If any person shall act or engage to act as a conductor on a railroad train in the state without having for 2 years prior worked in the capacity of a brakeman or conductor on a freight train. Okay. So apparently there's a requirement that you have to be a brakeman or conductor, and he had to be a brakeman or conductor for 2 years to actually work as a conductor, right? So basically, you know, you have to somehow so before the law passed, right, if you look at to be a conductor, you had to be a conductor before the law had passed, right? Now the only other way you can become a conductor is by being a brakeman. All right. What do you think the purpose of this law is? What do you think the purpose of this law is? Probably for the safety, right? Just like a Beezer case. That was for transit authority, 그러니까 교통국 직원이었죠. So people operating trains, who are also involved in visa. Same thing here. The general goal is to run trains safely. What does the court say about this? I mean, if you follow Beezer, what should be the result? I mean, what should be the standard of review?
Rational basis.
Rational basis review, because this is a non-speech. But what does the court say? Court says unconstitutional. So, page 300 of the resource book. Actually, 299. Let's start with that. The statute here under consideration permits those who had been freight conductors for 2 years, 화물차 차장 2년 동안, before the law was passed, and those who for 2 years have been freight conductors in other states, 여기 텍사스죠, 그러니까 다른 주에서 하고 왔거나, to act in the same capacity in the state of Texas. But barring these exceptional cases, 법 통과하기 전에 했거나, 그거는 이미 차장이었거나, 주 바깥의 차장이었거나, 이런 경우가 아니면은 반드시 brakeman만 할 수 있도록 하고 있는데, the statute does not require the brakeman to prove his fitness, though it does prevent all others from showing that they are competent. The Act prescribes no other qualification for appointment as conductor than for 2 years. The applicant should have been a brakeman or freight train conductor. 여기 conductor란 말이 빠졌네. But affords no opportunity for any others to prove their fitness. It thus absolutely excludes the whole body of the public, including many railroadmen, from the right to secure employment as conductor on a freight train. So it's like Beezer, right? One-third method users could be as good employees as non-method users. A lot of people who are never a conductor for 2 years before could also be a conductor. People who have not been a brakeman could also be a good conductor, because there are many other jobs that give you the knowledge and exposure that's required of being a conductor. Paragraph below, for it is to be noted under the statute not only the general public but also 4 classes of railroad men familiar with the, I'm sorry about keep saying men, this is 1910, so their gender consciousness is really bad here. Railroad men familiar with the movement and operation of trains and having the same kind of experience as a brakeman are given no chance to show their competency, but are arbitrarily denied the right to act as conductors. The statute excludes firemen, engineers of all trains, and all brakemen and conductors of passenger trains. But no reason is suggested why a brakeman on a passenger train should be denied the right to serve in a position that the brakeman on a freight train is permitted to fill. Both have the same class of work to do, but both acquire the same familiarity with the rules, signals, and methods of moving and distributing cars. And if the training of one qualifies him to serve as a conductor, the like training of the other should not exclude him from the right to earn his living in the same occupation. 기차 안에 화물이 들었건 승객이 들었건 기차 운전하는 건 똑같은데 화물차에서 브레이크만 한 사람만 하게 되는 거만 컨덕터가 될 수 있다는 거. 이거 arbitrary하다. And then it goes on how this rule does not make sense. And then the court has page 300, paragraph 3, so that the case distinctly raises the question as to whether a statute in permitting certain competent men to serve can lay down a test which absolutely prohibits other competent men from entering the same private employment. It would seem to ask the question is to answer. 너무 자명해서 이렇게 질문하는 순간 답이 나온다 이런 얘기죠. The answer in no way denies the right of state to require examination to test fitness and capacity of brakemen, firemen, engineers, conductors to enter upon a service fraught with so much of risk to themselves and to the public. 시험을 보는 건 괜찮다. 근데 지금 시험 보는 게 아니라 뭘 하고 있어요? 컨덕터로서의 경험, 아니 컨덕터로서의 자질과 관련 없는 그런 요건을 제시하고 있다. All men are entitled to equal protection of the law in their right to work for the support of themselves and families. A statute which permits the brakeman to act because he is presumptively competent and prohibits the employment of engineers and all others who can affirmatively prove they are likewise competent is not confined to securing the public safety, but denies to many the liberty of contract granted to brakeman operators to establish the rules of promotion in a private employment. So this is one real case. Now you can see what provision was invoked. Equal protection, right? I mean, in a case like this, if you apply equal protection, I mean, when you restrict a right, when you restrict a right to do something, you are also discriminating against the people trying to exercise that right. So it is both equality and liberty case. So you can go either, but the result is the same in this situation. And the court strikes down. So how was that made possible? How was such non-speech restriction was struck down as unconstitutional? We have to go back to paragraph 1 of the case. So page 298, paragraph 1. Life, liberty, property, and equal protection of the law grouped together in the Constitution are so related that the deprivation of any one of those separate and independent rights may lessen or extinguish the value of the other three. Insofar as man is deprived of the right to labor, his liberty is restricted, his capacity to earn wages and acquire property is lessened, he is denied the protection which the law affords those who are permitted to work. Liberty means more than freedom from servitude. The Constitution guarantees an assurance the citizen shall be protected in the right to use his powers, mind, any lawful calling. Okay. Now, page 299. the court cites Nashville versus Alabama, okay, where the court sustained the validity of a statute which required all locomotive engineers to submit to an examination for color blindness, okay, then provide that those unable to distinguish signals should not act as engineers on railroad trains. That was upheld. But at the same time, paragraph below, the necessity of avoiding the fixing of arbitrary test was also recognized in Smith versus Alabama. There, the Act provided that all engineers should secure a license, and in sustaining the validity of the statute, the court pointed out that the law requires every locomotive engineer shall have a license, but it does not limit the number of persons who may be licensed and prescribe any arbitrary conditions of the grant. And also it was upheld. So, in both cases where the statute was upheld, the statute was found constitutional, the court kept saying should not be arbitrary. Here, is it arbitrary? In this case, Smith versus Texas, the court is saying, yes, it is arbitrary. Because here's this person who worked for 22 years, right, in the railroad, and had been doing everything but freight conductor or freight brakeman. But other jobs could give him the same experience. And yet he was denied employment because of the law. So there are times that non-speech restriction can be struck down for being completely arbitrary. Now, if you look at Smith versus Alabama, the court says, hey, the court upheld the statute, upheld the licensing statute. 그러니까 면허제로 한 것에 대해서 누가 이제 헌법소원을 제기한 거죠. 근데 그거에 대해서 법원은 아니 면허자 숫자를 제한하는 것도 아니고 안전을 위해서 필요한 거 아니냐 라면서 합헌 결정하죠. 근데 거기서 전제는 뭐냐면 숫자를 제한한 것도 아니고. So this is where I'm going to talk about the Korean bar examination. What's the purpose of limiting the number of new admittees? The protection of the public, right? The protection of people using the services. Now, we pick lawyers by an exam. So what the court is, what the rule is trying to do is make sure that new lawyers have achieved minimum experience or minimum knowledge and skills to act as a lawyer, and provide sufficient supply of that. It's not that good to have a small number of lawyers for the public, right? Because, okay, so there are 100 good lawyers. Well, there are 100,000 people wanting to use lawyers. If there are just 100 good lawyers, that's not good, right? So the goal of the Korean bar exam is a sufficient supply of good lawyers. Does the limitation on the number serve that goal? Or is there a rational basis to believe that the number limitation, 1,000 under the previous exam and 1,500 under this exam, does that serve the goal of providing a sufficient supply of good lawyers? I don't think so. Because few things happen if you limit the number of lawyers. Number one, it does not provide a sufficient supply. Number two, those who became lawyers, they don't have to compete among themselves. They don't have to improve themselves to get the business. That's why before the law school came in, the joke was that the people who speak least English are lawyers because they didn't have to. They didn't have to study. They didn't have to specialize. They didn't have to acquire new skills. So, number one, it does not provide sufficient supply. Number two, it makes the existing lawyers stagnate. stagnate, 퇴보한다는 얘기죠. 또는 정체한다는 얘기예요. Stagnate in quality. So even the quality suffers. So number one, the quantity suffers. Number two, quality suffers. Number three, people who are qualified to become a lawyer cannot become one. Why? Because if the number is restricted, you are not judged on how well you do. You are not judged on how qualified you are for becoming a lawyer. You are judged on whether you are within 1,000th or 1,500th. 1000등, 1500등 안에 드느냐가 중요한 거지. 얼마나 지식과 기술이 있느냐가 중요한 게 아니죠. So what happens? The students studying for the bar exam fall into prisoner's dilemma of having to study infinite amount because they don't know what others are, how much others are studying. Oh, if others are studying this much, okay, then I'll just study that much to become, to come within 1,000 or to come within 1,500. But knowing that, these other students will study more. And knowing that other students will study more, knowing that I'll study even more. There's escalation ad infinitum, so that the lawyers, the students who are qualified, so the cutoff line at 1,000th or 1,500th will be very high, unnecessarily high, which makes the profession full of many good exam takers, but not good lawyers. So we filed a constitutional challenge on both grounds, failed both times. Hope that changes, and hope hear from cases like Smith versus Texas or Smith versus Alabama. Okay, any question, comment on occupational freedom?
Nowadays they review on the rational basis, not like Smith versus the state of Texas, right?
Yes.
So it's like a...
But even under rational based review, the number limitation, I believe, will be struck down. That's why American bar exam doesn't have a number limitation. Whoever achieves a minimum score can become a lawyer, no matter how many are produced that year. Actually, there is no profession in the United States or any other country where the number is restricted, like in Korea. Barristers in UK are restricted, but there is no national limit. It is only because the 4 Inns of Court that you have to graduate to become lawyers to be barristers have, you know, capacity limit. Just like all the law schools have capacity limit. But solicitors, which is the other half of, not the other half, the other 90% of the profession has no number limit. So UK has about 160,000 lawyers, 16만 명 정도. Germany also has no number limit, has more than 200,000 lawyers. Now, these are comparable countries to Korea. Germany has a population of 80 million. UK has about 60 million. How many lawyers are practicing in Korea now? About 20,000. Very small compared to, I mean, I'm not going to even compare to the US. I mean, there are just so many lawyers there, so comparing there is not, I mean, the US is exceptional in every way, but France also has more lawyers, many more lawyers, about 5 times more per capita than the number of lawyers in Korea. What's more important is there is no absolute limit on the number. But if you get an exam question, well, you have to apply rational basis review. But does it mean that all laws pass rational basis review? No. If it's completely arbitrary, then it will be struck down. Okay.
Professor, is it like the number cap the only problem?
I think the number cap is the origin of many problems. What problems do you see?
Like, there are only a limited number of schools that can accept a limited number of students to law schools in Korea.
Yeah, but then again, if it's not unconstitutional to require some education before the bar exam, then the schools are bound to have capacity limits. Now, the question is it okay for the state to limit the number of law students? I also think that is unconstitutional. I think that more schools, if they are capable, should be allowed to admit law students who can later sit for the bar exam. I mean, right now, I mean, the quality of law schools in other parts of the country falls below those schools, falls below some schools, say, within Seoul that don't have a law school program. So those schools actually filed a constitutional challenge. They also lost as well. You know, they argued they are capable of training people into lawyers. You know, these schools, these other schools, they've got into the national quota. We didn't. It is unconstitutional. Also, they argued that capping the number of law students itself is unconstitutional, but they all lost. Why am I talking about these failures, these failed lawsuits? It shows how different constitutional law is between American law you are learning and Korean law.
What do you think of the occupational rights for people who only graduated high school, those who want to become lawyers?
I don't think it's unconstitutional to require education. Yeah. I think that I don't think it's unconstitutional to require education as a prerequisite for a license. So, and number one, there are so many colleges now of so many colleges in different regions, offering scholarship. I don't think it's unconstitutional to require like school education as a prerequisite for a bar license. And you also have to think about whether alternative is good enough, right? If lawyering requires some exposure to your peers, or living in a community, or studying together in a community, which is what you often have to do in a law firm. You have to be working effectively with your colleagues. Then studying in an ordinary school, I think it can be a requirement. What's more important is this: the people who are arguing that high school students or high school graduates should be allowed to take the bar exam are not arguing to remove the number cap, right? They are arguing to keep the number cap, right? And then have that small number of high school students to pass that, right, small quota. Which is like, we are all for high school graduates, so we'll pass out these lottery tickets, right? I mean, yes, the government can work for the people. If the government can say they work for the people just by passing out lottery tickets, 복권 나눠준다고 해서 그게 복지 사업이 아니잖아요. Okay, let's go to property right. So, okay, does anyone have a copy of the syllabus with you right now? No? Okay, let me look it up. Okay, so eminent domain. Eminent domain clause, page 301. Eminent domain clause provides nor shall private property be taken for public use without just compensation. The clause has two requirements. Number one, all takings must be for public use, and even takings that are for public use must be accompanied by compensation. So, let's consider this. Let's consider this. Do you think this is a higher protection or lower protection than, say, freedom of speech or non-freedom of speech? Okay. Free speech, non-speech, property. 재산권. Is it like this or is it like that? So in order to govern, in order for the government to restrict a property right, it has to be for public use, and it has to be for compensation. Do you think this is a higher protection than protection given to freedom of speech, or no? What do you think? The requirement that the taking, 수용이죠, taking, is for public use. Is there a similar requirement for restriction of free speech or restriction of non-speech right? What do you think? Of course there is already, right? Think about it. Even rational basis review, now you know that rational basis review apply both to equality and liberty, freedom side, especially to non-speech right. And what's the requirement of rational basis review? 2, right? It has to work for a legitimate governmental interest, and it has to be rationally related to that governmental interest. Now, also in strict scrutiny requires the governmental interest not just be legitimate, but be compelling, much more important. So again, the requirement of publicness is already there for free speech protection and for non-speech right protection. But look at the second requirement. Even if it's for public use, the government has to pay money. Think about it. In free speech case, if the government shows that there is clear and present danger and suppresses the speech, can the speaker receive money from the government? I mean, if the government passes the strict scrutiny or rational basis review, whatever the constitutional test, can the citizens receive compensation from the government? No. Here, even if the government shows legitimate governmental interest, the government has to pay money. Right? In that sense, this is a higher protection. But at the same time, there is no other requirement for the government to fill, right? When you look at free speech restriction, or when you look at speech restriction or non-speech right restriction, there is other requirement than the governmental interest being legitimate or important or compelling, right? What is that requirement? So strict scrutiny requires the state action to be for compelling or action to be narrowly tailored 그 다음 뭐라 해야 돼요? For compelling governmental interest. Rational basis review는 state action be rationally related legitimate governmental interest. Intermediate scrutiny도 state action be substantially related important governmental interest. So there's a requirement that its objective has to be compelling, important, or legitimate, but also the state action has to be narrowly tailored or substantially related. Now, for property right restriction, is there a similar requirement as this? Now, this is called ends test. ends, 목적. 목적 심사라고 하죠. 목적이 중요한가 따지는 거고. 이걸 목적 심사라고 부르면 이건 뭐라고 불러요? 한목적성 심사. 그래서 여기에 이제 방법의 적정성, 한국 헌법으로 따지면 비례 원칙 4가지 요소 있잖아요, 그죠? 그러니까 목적의 정당성이 이거고, 방법의 적정성 하고 침해의 최소성이 한목적성에 해당하는 거죠. 그리고 법익의 비례성은 양쪽에 다. 비례성은 엔즈 테스트도 들어가고 한목적 심사에도 들어가고. 왜냐면 법익의 비례성은 이 프라이빗과 퍼블릭 사이에 이걸 따지는 거니까 프라이빗이 크면 퍼블릭도 같이 커야 되는. 그래서 이 목적 심사도 해야 되지만 그것과 비례해서 이 프라이빗이 더 작아야 되니까, 프라이빗이 더 작아야 되는 거니까 작게 하기 위해서는 이 한목적 심사를 해야 되는 거고, 한목적 심사는 영어로는 이건 이제 목적 심사고, 이거는 means, ends, nexus test라고 그래요. means, ends, nexus test. 또는 그냥 줄여서 means test라고 해요. means test. 방법 심사. 또는 이게 이제 방법의 한목적성 심사예요. 방법의 한목적성 심사. 줄여서 이제 방법 심사라고 스스로 means test라고 하기도 하고, 방법의 한목적성 심사는 means, ends, nexus test. nexus. 연결성. 네. Now, for property right protection, is there a constitutional requirement of the means test? No. All they have to do is just pay money. So in that sense, property right protection is lower. Okay? Than non-property right. Okay? Now, see, time. Let's look at Hawaii. Let's look at Midkiff. So basically this is what's happening. So Hawaii was a kingdom, right? So the land was owned by king or its royal families. And then without democratization, Hawaii was annexed to the United States. So the land was still in the hands of the king and the royal family. So the government had this issue of promoting land ownership by ordinary people. And how did they do? They allowed paragraph 3, the third paragraph of the case, tenants living on single family residential lots are entitled to ask the Hawaii Housing Authority to condemn the property. condemn은 수용한다는 얘기예요. condemn, 수용. 그리고 거기 fee simple이란 말 나오죠. fee simple. 그 위 문단에 보면 fee simple은 이건 이제 영미권에서 되게 복잡한 얘기인데 fee simple이 아닌 것도 많아요. 그러니까 공동으로 소유한다거나 또는 살아있을 때만 소유한다거나 이런 다양한 소유 방법이 있었는데 한국은 거의 전부 다 부동산이 fee simple이에요. 사실 fee simple 아닌 부동산 내가 본 적이 없어. 근데 영미권에서는 예를 들어서 땅을 주는데 당신 살아있을 때만 당신이 소유하고 죽으면은 다른 사람한테 줘야 한다. 죽으면 나한테 돌아와야 된다라거나 이제 그런 심플하지 않은 그런 여기서 fee는 그 소유권을 말하는 거예요. 소유권. fee는 무슨 수수료가 아니고. 그래서 뭐냐면은 그 일반 집에서 살던 사람들은 요청을 해가지고 그 땅을 살 수 있도록 한 거예요. 세입자들이 이 지주로부터 땅을 살 수 있도록. 가격은 어떻게 정하겠어요? 국가에서 정하는 거지. 이 정도면 적정하다. 이렇게. So if you look at the paragraph right below, when 25 eligible tenants or tenants own half the lots in the tract, whichever is less, file appropriate applications. The Act authorizes HHA to hold a public hearing to determine whether acquisition by the state will effectuate the public purposes of this Act. If HHA finds that these public purposes will be served, it is authorized to acquire at price set either by condemnation trial or by negotiation between lessors and lessees the former fee owner's full right, title, and interest. After compensation has been set, HHA may sell the land titles to tenants who have applied for fee simple ownership. Now the challenge. Hey, this is not for public use. This is for private use. Who Who are the private parties? The lessees. This is redistributing land from the rich to the poor. That's for a private purpose of poor people's land ownership. What does the court say about that? Page 303, the third paragraph. We have no trouble concluding that the Hawaii Act is constitutional. The people of Hawaii have attempted to reduce the perceived social and economic evils of a land oligopoly. 그러니까 토지의 과점 때문에 사회적인 경제적인 문제가 너무 많았다. The land oligopoly has, according to the Hawaii legislature, created artificial deterrents to the normal functioning of the state's residential land market and forced thousands of individual homeowners to lease rather than buy the land underneath their homes. Regulating oligopoly and the evils associated with it was a classic exercise of the state's power. We cannot disapprove of Hawaii's exercise of this power. So, that's it. So the last paragraph, the mere fact that property taken outright by eminent domain is transferred in the first instance to private beneficiaries does not condemn that taking as having only a private purpose. Okay? So there is the requirement of publicness. So as long as the publicness is proved, Wait, any question about what I've been saying so far, whether it's lower or higher protection?
So what you said is, what you pointed out is that depending on how you look at it, it could be stronger or lower.
Stronger protection or weaker protection, right? It can be stronger protection because
you pay money. So in that sense, that's
right. You have to pay money. Yeah. Okay. That's right. That's right. It's a lower protection because the government has to meet the means test, right? So right, it's a lower protection in a sense that as long as it's paying money, right? As long as it's paying money, the government can do it if it shows public use. But it is stronger protection because even if the government proves publicness, public goal, the government has to pay money. So that's why it's depending on whether you see the cup as half full or half empty, you can see it as stronger or weaker protection. Okay, good. Thank you. Thank you for. I was a little confused. Now, let's look at. Well, before I go forward. Is there Is condemnation, 수용, does condemnation happen often where land is transferred or property is transferred from one private person to another private person? Against their will? I mean, if they voluntarily transfer, then there is no state action, right? Is there a forced sale? 수용할 때, is it often that condemnation involves forced sale from one private person to another private person? 거의 모든 재개발에서 그렇게 되죠. 상가 재개발도 그렇고 주거 재개발에서도 그렇고. 왜냐하면 재개발을 하려면 redevelopment, right? Commercial redevelopment, residential redevelopment, it always involves forced sale from the owners who don't want to go through redevelopment and who don't have money to go through redevelopment. I mean, redevelopment requires money. So they have to borrow against their land to go through redevelopment. So that's why there's a requirement that like more than 70%, probably more than 70% for, I think, for residential, and more than 66% for commercial. Okay, these numbers are, I hate numbers. I don't remember them. I don't know these numbers. But there's a requirement that if more than 70% of the landowners agree to redevelop, then the owners who don't want to go through redevelopment are forced to sell their lands to the ones wanting to do redevelopment. But because it's a forced sale, it's a condemnation, it's a taking, it has to be for a public purpose. So what public purpose? In Korean redevelopment market, what public purpose is given to redevelop, say, apartments? Safety, right? So usually the buildings are too old. They may crumble down. So we have to do, that's why we have to go through this taking, go through condemnation, go through forced sale to do redevelopment. That's why when you drive around, you see these placards saying, "Congratulations, we received very bad grading on the building safety test," right? So that they can go into redevelopment. It was put up by the landowners who want to do redevelopment. The rich, usually the rich landowners. So there's a lot of discussion whether that is really for public use, or is it for the benefit of the rich landowners who want to make more money on their land. Same thing with commercial redevelopment. What's the official title of commercial real estate development in Korea? 도시 정화 사업이에요. 정화. Beautification. So, I mean, it's mind-boggling for a lot of poor commercial tenants, who cannot afford high rent at the newly redeveloped place, who have to be kicked out of the place just for the goal of what? Making the area look pretty. Right? I mean, they build their whole life. They made their living so many years on that commercial area, and they created all the pedestrian traffic. Actually, they are the ones who raised the land prices, right? But now the landowners want to use the increased land prices. I mean, land prices were increased by the work of the tenants, but now they want to redevelop. And the tenants who cannot afford rent have to be kicked out. And also, even among the landowners, just like residential redevelopment, 이 저 고대 앞도 그렇죠. 고대 앞도 그 상가 하시는 분들이 뭐 고대 정면 앞이 그렇게 장사가 잘 되는 데가 아니니까 돈을 많이 못 버셔서 재개발하는 거 반대하세요. 돈이 없으니까. 왜냐하면 재개발한 다음에 재개발하는 돈 빚을 계속 갚아야 되거든요. 그런데 이제 돈 많은 사람들은 이제 하고 싶죠. So is that really a public purpose for redevelopment like that? I mean, if the buildings are really unsafe, if the commercial area are really dirty, yes, you can find a public purpose in effecting the forced sale. But is that really for public purpose? So there, you know, redevelopment happens, so many redevelopments happen in Korea because the protection for property right is weak in a sense. Because as long as just compensation, 정당한 보상, as long as just compensation is given, there is no other requirement than that. There's no other requirement than that the purpose be public. Okay, I'll stop here. We'll read Mahon and Penn Central. 거기까지일 거예요 아마. 다 읽으라고 안 했을 거예요 내가. 그치? Penn Central, 마흔하고 Penn Central까지만 읽으면 돼요. And we'll discuss that, and also we'll discuss Roe versus Wade on page 334. 그리고 요거 상가 재개발에 관한 케이스는 저 327에 있어요. 예. 자, 수고했습니다. 금요일 날 볼게요.